introduction of Mediation Act 2023 signifies India's resolve to align its legal framework with international best practices. Our arbitral institutions must leverage technology, digital filings, hybrid hearings, and AI-assisted case management to reduce time and cost. But we must equally preserve what technology cannot provide, the human discernment that senses equity in every fact of pattern. As Lord Diplock once observed, I quote, "The judicial process is not merely logic, but the application of reason informed by experience," unquote. My lords and ladies, is the balance we must maintain, the marriage of efficiency with empathy. Justice must be not only digital in process, but dignified in purpose. The judiciary now faces disputes that no previous generation of judges could have imagined. Smart contracts, crypto asset regulation, blockchain-based property transaction, and metaverse arbitrations. How do we define jurisdiction over a transaction that exists only in cyberspace? How do we assess the validity of an agreement written in code? Can an AI-generated legal opinion qualify as an expert evidence? These are the questions. These are not hypotheticals from the future, they are the realities of the present. In Trimex International versus Vedanta, the Supreme Court, that is reported in 2010-8 SEC page 1, the court recognized the validity of email contracts. The next turning point will likely involve smart contracts executing autonomously through blockchain. The judiciary must now interpret not just the clauses of a contract, but the logic of an algorithm. This complexity calls for intellectual agility. The judge of tomorrow must not only know the law, he or she must understand the technology that shapes it. Our innovation institution has embraced change. The e-courts project, National Judicial Data Grid, and AI initiatives such as SUPACE demonstrate that technology can enhance, not diminish, judicial function. But as we digitize our systems, we must not digitize our souls. The ultimate safeguard of justice will always be human conscious. A machine may deliver information, only a judge can deliver understanding. Therefore, judicial education must evolve from procedural training to technological literacy. Every court should be a learning court. Our academies, such as this very judicial academy, must become laboratories of judicial jurisprudence. Commercial law has never respected frontiers. But in digital economy, borders are not merely porous, they are invisible. A contract may be negotiated in Delhi, signed in Singapore, executed in London, and breached in cyberspace. Arbitration is therefore a bridge between the commerce and certainty. India's vision to become an international hub requires more than legislation, it requires confidence. Confidence that our courts will uphold arbitral autonomy, support enforcement, and resist intervention except where justice demands it. For commerce to flourish, contracts must be trusted. For contracts to be trusted, courts must be predictable. Balancing dharma and development. At this juncture, allow me a brief philosophical reflection. Our ancient jurists, from Kautilya to Yajnavalkya, understood that trade and justice are two sides of same coin. Kautilya wrote in Arthashastra, I quote, "The prosperity of a nation depends upon the righteousness of its commerce." That principle holds true even in the algorithmic age. Dharma in the digital era means ensuring that innovation never outspaces integrity. As we craft new doctrines from emerging markets, let us remember that technology is a tool, not a teacher. The ultimate guide must remain the conscience of justice. We must approach complexity not with anxiety but with curiosity. When courts engage with cryptocurrency disputes, they are not merely deciding ownership, they are deciding the law of the value itself. When they interpret digital evidence, they are redefining the truth in a data-driven world. The judiciary of the future will not be remembered for the cases it decided, but for the questions it dared to ask. Our judgments must show that while statutes may lag, interpretation can lead. I am delighted to see international collaboration represented here by Mrs. Maria Sko, Deputy Director General of Danish Patent and Trademark Office. Intellectual property law and digital innovation are deeply intertwined, and India can learn much from comparative experience in Europe, particularly in data-driven IP enforcement and cross-border technology licensing. Such exchanges reminds us that commercial law is a global by nature and search for justice transcends jurisdiction. In the court of global commerce, the language of fairness is universal. The path ahead before us is, as we deliberate over the coming sessions on technology, arbitration, artificial intelligence, blockchain, and digital trade, let us view them not as an isolated phenomena, but as expression of a single transformation, the convergence of law and innovation. Commercial and arbitration law are not static framework. They are living organisms and must adapt to rhythm of global change. Our challenge is to ensure that certainty and creativity coexist, that we uphold predictability while allowing progress to breathe. The law that refuses to evolve risks extinction. The law that evolves without restraint risks chaos. The art of judging lies in finding the middle path. As I stand before this august gathering, the Chief Minister, the Solicitor General, my esteemed brethren from the Supreme Court and the High Courts and the members of the Bar, I am reminded that this dialogue is not about technology alone, it is about trust. Every reform in commercial law, every arbitration award enforced, every contract upheld, all of it contributes to the trust that sustains our Republic's economic future. Let us therefore pledge that our courts will remain swift without being hasty, digital without being detached, and modern without being mechanical. The future belongs not to those who automate justice, but to those who animate it with wisdom. May this conference be not just exchange of ideas, but a reaffirmation of our shared mission to ensure that the law keeps pace with life, and that justice, however complex the horizon, remains our northern star. Jai Hind, Namaskar, and thank you for lending your ear.
Thank you, my Lord, for offering insights into the ever-evolving field of technology and commercial law. I now request Honorable Mr. Justice Rajesh Bindal, Judge Supreme Court of India, to kindly guide us with his Lordship's address.
A very good morning, Namaskar, and in Punjab we say Sat Sri Akal also, with copy to all. Dignitaries honored of the dais, colleagues, lawyer friends, students, ladies and gentlemen, I will not name all of the dignitaries present here. It has been said number of times. We are in a digital world, as the subject is also there, so I can always copy and paste. So I start with that. Thanks for inviting me. When I saw the minute-to-minute program, you have seen that it is all on a very fast track. Number of speakers, small time. The idea is to give more inputs, basically. Star points come in the beginning only. Whatever vision is there, whatever idea somebody has. And everything is on the fast track now. We also have in court fast track courts. Whether they move fast or not, we can't say. But the fact remains the fast track courts are there. But one fact is there which cannot be denied, that a lot of work is being done on our system. If we see our data, and everybody is normally surprised to see, many of us don't see also. In 23, how much cases were filed in the country? It was 2.38 crores and 2.233 crore decided also. 24 also 2.46 crore filed and 2.34 crore decided. This is not a small number, about 21,000 judges. So everybody talks about, because we are also there to see that how we can fast track these litigation, commercial litigation, so that the contracts are also there and we get that litigation. But one problem is there, as we all see, that is the infrastructure, and that is the problem everywhere. Now, the idea of this colloquium has already been shared. What we are seeing is that what we have done in past, what are the problems we faced, and future, yes, in digital world, lot of things are there, lot of challenges will come, which we have to face. How our business is increasing, commerce is increasing, we all know we are the fourth largest economy now. Fourth largest economy means a lot of business. And that is evident even from our revenue collection also. Revenue collection is also one of the major part is the business only. And in that also, if somebody is concerned with commerce and all that, I think technology has also helped a lot, because of which our collection in revenue has increased manifold in last 5-7 years, 10 years. So this is, if the business will increase, certainly the disputes will also increase. And if the dispute increase, then solutions are found in the court only. And if you go to the court, one is the normal process. Second is, yes, we go for arbitration also, sometimes mediation also. And for the court, we have the commercial court sector also, fast track the litigation. But one problem which is being faced, dockets are there is no doubt about it. But I saw one of the reasons why this process is delayed. I think in Supreme Court in 2009 had commented poor drafting of the arbitration clauses or the agreements. What the Supreme Court said is really surprising, about 15 years, 20, it was said. It's a M.K. Abraham's judgment, 2009 as 7 SCC 636. I just read from the paragraph. The use of multi-layered agreements with several printed annexures, each with cyclo-styled amendments, typed and handwritten additions and deletions led to confusion, uncertainty, delays in execution, apart from giving rise to avoidable disputes, having a contract with different annexures dealing with the same issue with various attachments in construction contracts, and sometimes insurance contracts is a nightmare to anyone. So this is what is happening, and especially in the government contract we see all these kind of things, and in the private also a lot of mails and communications also enter into finally the contract. The best form of agreement is where all the relevant clauses, terms are incorporated in a single document with several sections dealing with different aspects, subjects, avoiding any overlapping. So why can't we use technology in this also and remove the error in drafting, which leads to a lot of litigation? And recently, I'll not go in detail, I think the Supreme Court has given a judgment to resolve the dispute. They say in 142 they can modify the award also, wherever I think it is required, so that the litigation is not just generated more by referring the matter back or maybe to the arbitrator or the appellate authority before that. If we read about the arbitration, what I read, in 24 it was about 16.5 billion US dollars, which is likely to increase in 32 to about $30 billion. Work on this side is increasing. But the problem is more of ad hoc nature, less of institutional. And in India, I think small disputes are more in ad hoc, though large are in institutional. The progress, I think, in our Mumbai center is good, that about 18 months the cases are being decided. Hyderabad also has very good result. And one positive aspect is that in Mumbai International Center they got about 15% litigation where the foreign nationals, foreign companies are also involved. This is very important and a positive aspect, that a lot of commercial litigation in arbitration is coming to our country. But one problem in ad hoc arbitration which I've seen is that we don't have the experts which may be available in the institutional arbitration, which is required because a lot of technicalities are involved in this. And one problem in arbitration which is being seen, technology can always help, is we don't have any data. How much arbitration is going and what are the subjects at different levels and what is happening finally. Why can't there be a data? There is nothing about the record keeping of the arbitrators. Who will retain the record? This is a major problem, I think, needs to be taken care of. Commercial courts are there, we have, yes, fast track, but I think there also we need to train. A lot of complicated issues are coming. We need to give specialized training to the officers heading it, and especially the technology, as has been already said. There is a need to change the mindset. And now we are living in a digital era. We can't escape from that. AI is there. It can be helpful in summing up the pleadings or summing up the arguments, yes, but it's a big challenge, as Mr. Tushar has shared, that somebody had gotten an award also. The allegation is prepared through AI. Now suppose in many countries there are AI courts, Now, if one AI decides a case where you will file appeal, maybe you need a second set of AI or second AI company which had developed the software to test that. We don't know where we will reach. But these are all very technical subjects which have been given, all have been referred to. But one online commerce also, I think there are a lot of AI courts, they have the resolution of that. But AI has its own problems also because a lot of evidence is being created by AI. That's a big challenge for the arbitrators also and the courts also to check that, to see that they are not misled by that evidence or something. And I read somewhere what meaning has been given to AI is artificial insult, imitation, or intended hurt. We are seeing the area of deep fakes, what is happening, and this is the problem in intellectual property also, innovations also. A lot of litigation is coming on that. But and in some cases, yes, I recall, non-existent judgments are also being cited. I think that also is a challenge for the courts also and the arbitrators also to see. And more responsibility, I think, on the lawyers also who are citing all these judgments. That's a big challenge we are all facing. The subjects are very important. I think we all go enriched with this conference, being the contemporary subjects. And I am thankful to the organizers for giving me an opportunity to share my little views on this subject. And I think this is all I can share, giving the time. Thank you. Jai Hind.
Thank you, my lord, for the profound words of wisdom. I now invite Honorable Mr. Justice Ehsanuddin Amanullah, Judge Supreme Court of India, to please share his lordship's thoughts with us on this special occasion.
Very good morning. Namaskar. Sat Sri Akal. Assalamu alaikum. I am very bad at taking names and remembering who all to address or not, so I think the shortest way is to address only the few dignitaries. Dr. Mohan Yadav, the Chief Minister of Madhya Pradesh, my esteemed senior colleague Justice Maheshwari, my colleagues Justice Bindal, Justice Arvind Kumar, Chief Justice Sajdeva, Madam Maria Sow, Learned Solicitor General, Justice Vivek Rusia, Justice Vivek Agarwal, and my brother and sister colleagues in the audience, my former dear sister, Justice Seema Kohli, Justice Gurish Kulkarni, brothers, sisters, students, men from the media. The gathering today is a little bit different from what we normally come to attend and what seminars are about. This is more of a thing which is now emerging on the horizon, and quite a lot of it is now relevant and has to be factored in, which probably in a country like India needs to be addressed at an early stage, given the volumes, the proportions, and the way India is emerging as a leader in all fields. I think rightly a decision has been taken, and I would also congratulate the team led by Justice Sajdeva to have conceptualized this type of a colloquium. The two-day collegium on evolving horizons, navigating complexities and innovation in commercial and arbitration laws in the digital world, which is a joint initiative of the Madhya Pradesh High Court, the Madhya Pradesh State Judicial Academy, and the Danish Patent and Trademark Office at Indore, is quite welcome at this stage of time. The world today is in a state of flux, if I may put it lightly, and this prevails across sectors, foreign, economic, trade, etc. The trappings of the office I hold prevent me from delving into this in detail, But if one were to look at it globally, the developments from a neutral perspective, one would be left with thinking to expect the unexpected. The legal profession is no exception to the global trends that are sweeping the globe today. The digitalization of economies has led to new forms of commerce, ranging from microfinance models to blockchain-based contracts to artificial intelligence-led supply chains. Such disruptions and innovations challenge the foundational assumptions that have conventionally guided contract law, including but not limited to its formalization, performance, and enforcement. As can be expected, when business and trade grow, commercial disputes increase. While Indian lawmakers have carried out reforms to the Arbitration and Conciliation Act 1996 and the Competition Act 2002, but they have also introduced now measures like the Commercial Courts Act 2015. Shifting gears, Europe a long time ago had witnessed the phase of lex mercantoria, or law follows the merchant, which phase, I am of the opinion, has returned inasmuch as regulatory authorities, judges, lawyers, and the like are scrambling to keep themselves ahead of the curve while also battling issues such as cross-border jurisdictional conflicts, enforcement of foreign orders, and connected matters. Insofar as the use of artificial intelligence and technology is concerned, with reference to the courts, the same is welcome. However, only to the extent that it aids the judge in determining matters. Preliminary stages of case processing and listing can and should be automated, but the judges and the human element in the act or art of judgment is what makes the system perform. An essential attribute of justice dispensation is that it must be tempered with mercy. In his 1990 book titled Power Shift, Knowledge, Wealth and Violence at the Edge of the 21st Century, Alvin Toffler has predicted that knowledge would come to rule the world. He had opined that in the fight between muscle, money and mind, ultimately the mind would prevail. In the present age, information is power. Simply put, knowledge of consumers and consumer habits is the new gold mine, and personal information has become a lucrative commodity, with business fighting to gain access to and utilize such data. The consequential fallout will entail privacy concerns. While the European Union and the General Data Protection Regulations, India has the Digital Personal Data Protection Act 2023. As we proceed, the interplay and overlap between such statutes and business interactions in the face of competing commercial freedom will require a tightrope walk to maintain delicate balance by all stakeholders involved, that is the courts, the regulators, the business community, as also the lawmakers. The integrity and fairness in the digital context does not only mean due adherence to an audi alteram partem, but includes the right to digital inclusion. There must be adequate safeguard against algorithmic bias. This will become significant with the expected increase in online dispute resolution mechanisms, and there are many platforms already available which are offering technology-based resolution pathways for litigation, arbitration, and mediation. We must also invest in capacity building, infrastructure development, and most importantly in digital literacy. The game and benefits cannot be allowed to remain to preserve of a few, but must be democratically shared with the whole populace. Humans have proven to be the most resilient of species, bearing in mind Charles Darwin's theory of survival of the fittest. In the long history of the world, even the fastest of changes are but a mere blip. When closer cooperation, solutions to the challenges that control us and to the ones which are likely to arise will surely be discovered or invented. As the adage goes, all good things to those who wait. The advantage I have of being among the last speakers is that I can say I humbly concur with what the speakers before me have said, and I hope to interact in greater detail during the course of the first session. I convey my special thanks to the organizing institutions, and I'm looking forward to the deliberations and the musings that is ahead. I am sanguine that we will be left with more food for thought. Thank you and Jai Hind.
Thank you, my lord, for the enlightening address. I now have the privilege of requesting Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, to kindly deliver the inaugural address.
नमस्कार. इनिशियली आई वाज थिंकिंग, सोच रहा था कि मैं भी कहूं कि भाई आई शुड नॉट नेम. मैंने सोचा ये दृष्टता होगी अगर मैं ऐसा करूंगा, बिकॉज आई एम इन मध्य प्रदेश एट माई होम. आई हैव टू फर्स्ट रेस्पेक्ट एवरीवन हु इज प्रेजेंट हियर. डॉक्टर मोहन यादव, ऑनरेबल द चीफ मिनिस्टर of the state of Madhya Pradesh, Brother Justice Ehsanuddin Amanullah, Brother Justice Rajesh Bindal, Brother Justice Arvind Kumar, Judges of Supreme Court of India, Brother Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh, Brother Justice Vivek Rushia, Administrative Judge, Indore Bench, Justice Vivek Agrawal, Chairman and Governing Council of the State Judicial Academy, Ms. Maria Skau, Deputy Director General of the Danish Patent and Trademark Office, Mr. Tushar Mehta, Solicitor General of India, Justice Hima Kohli, former Judge, Supreme Court of India, Justice Girish Kulkarni, Judge, Bombay High Court, Honorable Judges and their gracious spouse present here, Additional Advocate General present from Jabalpur, Indore and Gwalior, Additional Solicitor General present here, Chairman, State Bar Council, Sir Adilal Gupta, President, Secretary of the Bar Association, learned senior advocate, advocates, judicial officers, esteemed academicians, our participant from Danish Patent, and dear students, gracious ladies and gentlemen. When I was looking about this topic, and the speakers of today, at one end, Justice Arvind Kumar is with us. I have an occasion to sit with him. I know about his thought process and his eloquent ideas which have been come on floor. I think I need not to go more than that. When I think about technology, Justice Rajesh Bindal and Sanjeev Sachdeva is here. And I have an occasion to sit with Rajesh also. Then for technology, I need not to say much more. And when Amanullah is there, he is frequent visitor of everywhere. You can understand the ideas from every state across the India and globe also. But even when I was looking for this topic, I was seeing that international colloquium on evolving horizons, navigating complexity and innovation in commercial arbitration law in the digital world. I try to interpret this topic So when I was looking with two views, evolving horizon, navigating complexity and innovation, commercial arbitration law in the digital world, not otherwise. Another part is, what are the evolving horizons to navigate the futuristic approach with respect to complexity and what innovation we have in our mind. And that is why the world which is growing on in these days, commercial and arbitration laws, how it can be dealt with in the digital era. So this is, and I feel, the second thought process or second mindset may be a proper thinking for this colloquium. When we see this, we know laws are there, but it is required to be responded. And response is by the judgment, by way of discussion in colloquiums, by way of otherwise having expression through academicians. But the most and powerful tool is by way of judgment. We should not be reactive, but we should foresight the balance even at a stage of colloquium, even at a stage at a judgment, or even as an academicians. Though, whenever the academician thought of it, they always thought in one direction. The another academician thought in different direction. And it gives a space for discussion, and it gives a space for everyone and the thought process how we can give a response through judgment in a right perspective. Now we think on this, then we go by this aspect, then the real mean is, our goal is therefore is not to reinvent the law, but to extend its principles with fairness, certainty in new domain. When we do this, we have some problems. Those problems come to at present, because the topic of today is in digital world, what we have to do, how we have to navigate all these issues. So when we go for this,